Good morning, everyone. My name is Helena Nat. I'm the Executive Director with the Greater New York Chamber of Commerce. I thank you all for joining us. We'd like to keep timely, so we are going to start it. During this COVID times, we've been having a lot of informative webinars, and we'd like to bring in different aspects of ways for businesses to continue staying in business and making sure that you are doing everything right, that you are being covered on different options in regards to business insurance. So when I was speaking to Daniel Leav, and he had told me about his background for the interruption claims, I thought that this would be perfect for the businesses that support the Greater New York Chamber of Commerce. So Daniel, thank you very much for hosting this informative webinar. And he is a partner at Leav and Steinberg in New York City. So I am gonna turn it over to him in a minute. So for those who are joining us right now, put your information in the chat. Daniel is going to get a copy of all the attendees, so you don't have to worry about that. And I'm sure that he will, do a follow-up email so you have that connection with him. During his presentation, if you have any questions, there's a chat on the bottom. Put the information in the chat. I am going to monitor it, and I am going to tell Daniel the questions that is being asked, and he'll be able to hopefully answer your questions. If not, I'm sure that he will be able to get back to you personally with your information in the chat and the information that I'm going to give him. So right now I'm going to turn it over to Daniel Leav. Again, Daniel, thank you again for hosting.
Oh, it's my pleasure, and thank you, Helena. I'm not just a host of this, I'm also a member of the Greater New York Chamber. And the work that you guys do, especially during these times, has been really, really informative to me, my clients, my firm. So I want to thank you. In addition, I also want to thank the U.S. Veterans Chamber of Commerce, who got me involved with the Greater New York Chamber, and Adrian and all the good folks over there. By way of introduction, real briefly, myself and my firm got involved in insurance coverage litigation in a big way after Hurricane Sandy. Our background is as personal injury and trial lawyers, so we've been dealing with insurance claims for 20, 25 years. But in the wake of Sandy, a lot of businesses and people that I know, I live on Long Island, and my office is in Manhattan. People were putting in claims for property damage, business claims, restaurant losses, particularly on the South Shore of Long Island. And the carriers were taking the position that they just weren't going to pay for a host of reasons. So we got involved in litigating and suing insurance companies so that these businesses and homeowners would get coverage. And it really opened my eyes to an area of the law that I became very, very interested in. So that brings us to our current dilemma and these crazy times that we live in now. With COVID and the pandemic and the manner in which it's affected small businesses, and big businesses, but predominantly small businesses here in New York. So to get started, in order to make a COVID business claim against your insurance company, the first thing you have to have is a policy. Now, most business policies or business owners or managers, I assume that that's what most of you are that are on this webinar. If you run a business, you have liability or GL policy through a carrier. And you're paying your premiums every month, and hopefully you haven't had any claims, or if you have, hopefully the carrier's picking them up. Under a general liability business policy, there ordinarily is a section called business interruption coverage, or BIL coverage. And I'm gonna scroll down on this brief outline I gave here. Business interruption insurance, are we covered? Do you have a policy? If you have a policy, take a look at it. The chances are pretty good that there's business interruption loss coverage within that policy. What does business interruption loss cover? It covers a host of things, and I'm going to say this a lot during the webinar. It is very dependent on the language of your policy. But generally what it covers is business losses, loss of profits, payroll, cleanup costs, expenses, compliance costs to deal with what the government is telling us we have to do as far as social distancing and plexiglass and cleaners and those types of things. Again, in your policy there are certain things that are going to be named perils, which they're specifically covering. And then there are also policies that are all risk policies. If you take a look at your policy, you can get a better understanding of what particularly is covered under your policy. You have to remember that an insurance policy is a contract. Some of you or many of you may have already put in a claim saying, look, I have losses from COVID. I'm either going out of business or I can't operate. I need coverage. And your carrier turned around and said, well, based on these things, we're not paying. Okay, so what do? You just take it? The carriers are very smart. They understand that when people make claims, if they get a claim letter or a rejection letter on a coverage letter back from a carrier that's 4 or 5 pages and it's written by 100 lawyers and it's very well thought out, that the vast majority of you are just going to give up, that you're not going to pursue the claim. But it's a contract. And if you believe that the contract has been violated, you have a right to sue on that contract, just like any other contract. A contract in New York, in order to sue on a contract, there's a 6-year statute of limitations. You have to bring a case within 6 years of the breach, okay? The carriers are very smart though. You have to read your policy. The statute of limitations for suing your insurance company after you get a denial is much shorter. It's usually a year or sometimes 2 years, again, depending on what your policy says. So if we assume that COVID risk and the pandemic and your business losses started around March 15th of this year, if your insurance policy only gives you a year to bring a lawsuit, you only have till March 15th of 2021, which is what, 5 months away from now, in order to bring the coverage, or else you're forever barred. What is covered? And how are we going to claim that there's coverage for these things? Most policies cover what's called civil authority coverage. So here in New York, what happened was, we know Governor Cuomo and the other powers that be decided we're going to impose certain rules and executive orders on businesses that you can't open if you're a gym or a theater or a restaurant or a nail salon or a service business. You're well aware of what these executive orders said. Now, traditionally, executive orders could be covered under your policy unless there was an exclusion. We're going to talk about exclusions in a minute. I don't want to get too far afield on the minutia of insurance law with you guys, but it is something that you're going to have to deal with when and if you litigate with these carriers. Executive orders generally were covered, and for instance, if there was a fire or a riot down the block from your office, and the governor or the police department decided to shut the whole block down for a week or 5 days, you could make a claim for that. Okay, so executive civil authority or an executive order was covered. However, there are certain exclusions which are in a lot of policies, which we'll talk about. What else is covered? There's dependent property is often covered. If you use a venue outside of your premise, or if you have some other property that's covered, that should be covered under your policy. Contingent business coverage, letter C there. Let's say you're suppliers, or you're in the supply business, or somebody's supplying you, and the supply chain was coming from upstate or from California or wherever, and you had an interruption in your supply chain. Or the receiver of your goods, perhaps you're receiving goods at a warehouse here in New York, and that warehouse was closed. Generally, those types of things are covered. Communicable diseases, we'll talk about that too, because that's a big issue, obviously, with COVID. Some policies have communicable disease coverage, particularly schools, spas, gyms, salons, and things like that. And I don't want to get too far afield with that because we're going to discuss that a little bit later. Ingress and egress coverage is covered. If you can't get into your property because of damage, if you can't access your warehouse or your goods, event cancellation coverage, again, if you're running seminars or a golf club or whatever. So a lot of things are covered under policies, but the real issues that we're dealing with as lawyers for clients like small businesses are the exclusions. So those of you that have already gotten a denial letter from your carrier, you know that the carrier is saying this stuff's excluded. Well, what does that mean? That means obviously that they wrote into their policies certain things that they're not going to cover. All right. Generally, they're governed by local laws and they're construed very strictly against the carriers. So the carrier may say, well, you know, it says that you're not covered for any diseases, and COVID's a disease, therefore we're not covering. Well, that's not necessarily so. COVID's a virus. Okay, now I'm being a lawyer. Okay, guys, I'm really being very nitpicky here, but when we're talking about claims against carriers, language matters. Okay, the definition and dictionary language matters. Why? Because the carriers are the ones who draw up these contracts. You guys don't. They have every opportunity in the world to draw it up however they want. You have to sign it. So if they draw it up incorrectly or there's some little loophole that you can get through, that's how you drive a truck through it to try and get coverage. The choice of law is generally where the policy was executed. Most of you these policies are written out of New York. So if you have to deal with choice of law issues, in other words, you don't want to have to go litigate a case in Illinois if Allstate's your carrier and they're based in Chicago, right? But those issues, you know, you can talk to. The burden is always on us to prove the loss is a covered loss, and they have the burden of showing that the exclusion applies. All right, again, this is a lot of legalese here. Okay, let's talk about COVID. The big defense that we're seeing and the big reason for denials amongst carriers is what's called there's no physical loss. In other words, they're saying none of you guys your property wasn't damaged. Therefore, you don't have business interruption under your policy. Every policy that I've looked at, and I've been reading insurance policies on concerning COVID for the last 3 months, 4 months, ad nauseum, have a requirement that there be a physical loss or physical damage to your property. Well, we don't have that here, or do we? Okay, the carriers, those of you that have gotten denial letters, the carriers are saying there's no physical loss, therefore no coverage. That issue is being litigated now across the country by lawyers like me, who are saying and making arguments that just because there's no fire and just because there's no physical damage to the property doesn't mean that ostensibly we can't use our property because of COVID. All right? We kind of lost the case, not me personally. Fortunately, we were able to come in at the last minute and salvage a case that we thought was going in the wrong direction here in the federal court here in New York recently, where a judge did not issue a written decision, but she stated on the record that no physical loss, no coverage. Well, we litigated a different case in the federal court in Missouri, and they said, well, that's not necessarily so. We've covered asbestos cases. We've covered cases where there is bacteria in the water. We've covered cases where there's ammonia in fumes in your building. We've covered cases where toxic gas is spilled out. Why can't we cover COVID? So that is playing out now in the courts, and that's going to be really, I think, the penultimate issue in a lot of these cases. Again, you have to look at your policy as to what they say about viruses, microorganisms, communicable diseases, mold, pollution, contamination. Some of you have gotten denial letters from your carrier that we don't cover communicable diseases or mold, we don't cover mold or pollution or contamination. Well, this is none of those, okay? Is it a communicable disease? Yeah, it is. But your policy, if it doesn't specifically say that, maybe you'll get coverage where ordinarily you wouldn't have.
Daniel?
Yes.
Someone in the chat just want to go through, and someone in the chat is sitting there saying that this is exactly what I was told. No loss of physical property. I'm an event planner. No large events are permitted. Regardless of my office, my business is not permitted to function by executive order.
Okay.
Someone also said my policy specific excludes viruses and other bacteria.
Okay.
I was told by my insurance broker that no one is covered for BI due to a pandemic, primarily for interruption due to other causes such as fire, water damage. How could this be applied to the hospitality event industry?
Okay.
So
all excellent questions. I don't know if it came from one or many.
Many.
Okay. The first and most important thing is the requirement for direct physical loss. Okay, I've heard from a lot of insurance brokers, nobody's covered. Well, that's not necessarily so. And again, it goes by the language of the policy. Some policies, if you have a communicable disease exclusion, and it talks about the release of a communicable disease or the other manner in which it's transferred, may not be applicable to COVID. Now look, just because your broker is telling you you're not covered, okay, doesn't mean that you can't maintain a viable claim against your carrier. All right, what happened in Sandy was the carriers were coming in, let's talk about a split level ranch. Well, the basement isn't covered. Well, in a split level ranch, is the basement the first floor? Or is the basement, is the first floor a living room? Of course, the carriers are going to take the position that it's a basement. But a vast majority of my clients said it's not a basement, it's a living room. And by the way, some of it is above ground. So we made an argument successfully in the federal court and got almost 100 cents on the dollar, where most brokers were telling their clients, you're not covered. Okay? So as far as physical loss is concerned, I'm not telling you guys that it's a home run. It isn't. What I'm saying is that at the moment, and there probably are, the case from Missouri, which I just told you about, came down August 12th. So 2 weeks ago, all right, where a business owner, and in that case, I'm not sure what, it was a party company, brought a lawsuit against their carrier, and the carrier immediately moved to dismiss the case, saying there's no direct physical loss, therefore there's no coverage. And the court said, no, wait a minute. Let's take a look at some other cases where we did find coverage. Remember, the courts, particularly in New York, the courts, again, depending on the judge and depending on the court, are going to construe these policies very, very tough against the carriers. Okay? So just because you have a physical loss exclusion or requirement in your policy doesn't necessarily mean there's no coverage. Now, as noted here in my outline, depending on how your exclusion is written on your communicable disease, pollution, contamination part, that's another hurdle. If you don't have an exclusion for communicable disease, virus, microorganism, mold, etc., you're in a much, much stronger position. Why? Because the carriers have known about pandemics for a long time. Okay, SARS and all these bird flus and all this other stuff has been going on in Asia for 20 years. And the carriers were getting destroyed by claims from businesses in Hong Kong and China. And eventually they wrote into their policies these exclusions. Some policies have them, some don't. If you don't have them, you have a much better case. If you have one, it makes your case more difficult. We, amongst the trial bar, are taking the position that we're not really going to litigate the microorganism exclusion first in the courts. There's a concerted effort nationally amongst lawyers like myself. My partner is the president of the New York State Trial Lawyers Association. I'm very active in that. I'm very active in the American Association of Justice. And there is a concerted effort amongst lawyers like me to make sure that we have a national idea or strategy before we just willy-nilly go to court and challenge these things. The concern is that some local lawyer, and no offense to the guy with a shingle on, on Broadway, is going to go to court and we're going to get a bad decision on microorganism pollution. So we're monitoring them very, very closely. So the short answer, guys, is this. You may still have a claim. Okay, I'm not telling you that, and because your broker says, forget it, there's no coverage. And here I'm going to do a little pitch for trial lawyers. To hire an attorney like me, and again, I'm not soliciting business. I'm doing this because the chamber asked me to. I'm a small business owner. My business has been greatly affected. I do a lot of personal injury cases. But to hire a personal injury attorney or a litigator that takes these cases, it's done on a contingency fee, okay, which most of you know that the lawyer is looking for a piece of the recovery. So there's no outlay of money on your part. The risk is borne by the attorney. And we, amongst the industry and the people that do what I do, we have made a decision that we think this is a fight worth fighting. Can I guarantee you that you're going to have coverage? No, I can't. Okay, and any lawyer who says I can definitely get your money is not telling you the truth. But there is the option. And I think as a business owner, which I am, there's really no downside to business owners to at least taking a peek, particularly if the lawyer is fronting the money for the litigation. These will not be expensive cases to prosecute. The only real things are getting in touch with your accountant, finding out, and I'll just jump ahead for a minute since we're on that issue. How do we calculate our damages? What's our loss? And what's covered? Now, you may have $30 million in losses, but you may only have $1 million in coverage. So you have to figure out what your coverage is. Most policies, and here damages, how do we calculate? Under subsection A are what's called actual loss sustained policies, which means that your actual losses for at least a year, and again, you have to read your policy, some are longer, are the measure of your damages. So lost sales minus saved expenses, or net income plus continued expenses, and the like. Really what you're going to need, and I'll just go down to the bottom here, is to prove these claims. What do I need to prove my losses? As much documentation as you have, canceled orders, payroll. For those of the party planners who asked me the question, I had 9 events lined up, and here are the contracts. None of them went forward. And there's my loss. Cleanup costs, leases, tax returns between what you made in 19 and what you made in 20. Giving too much is always better. In some of the denial letters that you guys got, the carrier is requesting further information from you. And if you blow it off and you don't do it, well, now you violated the policy. So read your denial letter and make sure that you're sending them stuff that they're requesting, even though they may have denied coverage. They may have buried it on page 6. By the way, we're still continuing our investigation of your claim, which is nonsense, but that's what they say. But you need to send us a certified letter with X, Y, and Z in it within 60 days, or we're not going to look at it. Well, you have to comply. Getting back up to the outline. Are we okay question-wise, Helena, or?
Yeah, we're good.
Okay.
If you guys have any questions, put it in the chat. I'll be glad to ask Daniel while he's speaking.
Okay, so another question that I'm getting from a lot of clients, particularly business owners, is I got PPP money. I got money from the government. I got other set-offs, so to speak, to help my business. Do I have to pay that to the insurance company? The answer is maybe. Okay, if you successfully win the claim, okay, and this could take years. All right, will there be a set-off for the PPP money that you got? Let's say you got $500,000 in payroll expenses, and the carrier is now on the hook for more. Depending on the language of your policy, you may have to pay that money back to them.
Is that including the EIDL, the economic injury? All of them. Okay.
But again, none of this is yet written in stone. Okay. Obviously, we're taking the position that it's not covered. If it's not covered in the policy, it's going to be governed by local law, which is has what's called subrogation language. I won't get into the collateral sources. In other words, if you're injured and somebody else pays the damage, they get a reduction. But the bigger problem is going to be winning these cases in court.
Daniel, I have a question that just came in. The person wrote, my broker felt I had a claim. My carrier CNA entertained the claim, but sent a certified letter denying the claim. My claim was detailed with canceled contracts and copies of executive orders. The denial was full of might exclude, in quotes, and puts the burden on me to challenge the might, in quotes, excuse.
Okay, excellent question. And the answer is the burden is on the carrier. I don't care what they write in their claim letters to you. The burden is on the insurance company to show that the exclusions apply. It's not, the burden is not on the insured. The burden is on the carrier, all right? You're getting these letters, guys. The carriers are doing no investigation. There is an obligation under New York State insurance law that when you make a claim to your insurance company, that they actually investigate the claim. Okay, we had a lot of that in Sandy where they didn't even come out and look at the houses. They didn't come out and look at the businesses. Did any of these carriers come out and talk to you about how many people in the building where you work had COVID? Did any of them come to and find out how many people on your block died? On how many people within your area were hospitalized at Lenox Hill or Uptown or downtown or in Queens or Long Island? No, they did none of that investigation. So when we sue them, the courts are looking for, okay, you're denying coverage, but what investigation did you do, Ms. CNA, on this case? Well, nothing, we just looked at the policy. Okay, that may not be enough, right? The letters that I see, and I've read probably 50 denial letters, they all start the same way. We give you a policy, et cetera, et cetera. There's no physical loss, or there's an exclusion for X, Y, and Z, and therefore we're not paying. All right, so don't pay. So you know what you do? You have to have a judicial determination as to whether or not they're right or wrong. All right? Just because you got a claim letter that says we may or may not be right under the exclusion does not shift the burden to you guys to start doing that. But make sure you know if your CNA policy, somewhere buried on page 74, it says if you're going to sue us, you have to do it within a year. All right? And that's the only way they're going to pay you. They're not paying any, in Europe, they're paying some of these claims voluntarily. You know, that's not going to happen here. In a lot of states, including New York, they're protected. The carriers are, you know, they have the money. But my feeling is if we can get one or two of these cases in front of a jury, all you got to say is these good people paid their premiums for 30 years. And when you finally need the carrier, they hide behind a wall of lawyers to tell you, we're not paying. The hell with you. So that's my emotional plea. Right? That's why I'm a trial lawyer. But I hope I answered your question, but don't be intimidated by the detail of the disclaimer letter. You know, the disclaimer letter was written by a first year or second year associate from a standard form that every business owner in New York got. Okay, there are avenues that you can challenge. Again, I'm not telling you guys that these cases are a home run. They're not. This is going to be real difficult litigation, and we're going to have to be smart on the forum and smart on the cases that we handle. But as business owners, it is something that you need to, you know, be aware of.
One other question regarding the PPP. In the event of an insurance settlement where the client's company received a PPP loan, if there would have to be a payback, should that end up as a deduction from the insurance payment? I think you just answered that.
Yeah,
the PPP loan was a Fed-sponsored program and forgivable if the monies were properly used. I don't think the client would have to pay back the insurance company a few years later. That's what someone wrote.
Okay, whoever wrote that, I agree with the last thing you said. It's our position that it's not collateral source. In other words, it's not lienable by your carrier in light of the loan document that you signed for the PPP. I don't think is going to be applicable. However, I bring it up because the carriers, as sure as God made little green apples, they're going to take that position. They want that PPP money from you guys. Okay,
sure.
I bring it up because I don't want you to feel, and your broker may tell you this, or the insurance company directly. You may get an adjuster who says, "Well, you're going to have to pay the money back that you got from the government anyway." Well, not necessarily. Just because you're telling me that doesn't necessarily make it so. All right. There are no decisions that I know of, and I'm monitoring this daily, that have come down on the applicability of paying PPP money back or other government subsidies from the pandemic to carriers. What I'm telling you is it's definitely going to be an issue at the moment.
It's a good point. Very good point.
Okay, so I mean, the last thing I had here, and I know we had an hour. I'm only going to talk to you for about another 2 minutes. So, what do I need to do to prove my losses, and what do I do? All right, we went through some of the things here on my outline that you should be gathering, and the next thing you should be doing, again, and it's not a solicitation. Speak to somebody who has an understanding from the claimant's point of view as to what your rights are. Okay, some of your businesses are never coming back. And those that are coming back with less staff, mine included, all right? And at the end of the day, I love litigating against big carriers because they make stupid decisions. They make decisions that end up biting them. And eventually, I'm telling you from my experience at Sandy and my experience litigating with carriers, is eventually we're going to find something in these cases, the manner in which they didn't investigate, or a loophole in the physical damage. Remember, let's say you had asbestos poisoning or you had fumes in your building. Why should the carrier cover that and not this? How is that a different loss of use, an ostensible loss of use of your physical plant? How is that any different than this? Leaving aside a COVID or a pandemic exclusion. So I leave you with that. Fight for your rights, because they're not going to give it to you. And that's my thing. I hope it was educational. I'm certainly available. Helena's going to get me you guys emails. I'll try and shoot out an email. Again, not a solicitation. I'm a member. There are very, very good firms in the city who are handling COVID litigation. I am handling COVID litigation. We are still in the point where we're gathering cases. I'd say I probably have about 35 businesses that we're working with. I'm taking a little bit of a more not laid back, but I want to take a little bit more of a wait and see approach as to what happens nationally, so we can fashion our complaints in a manner that we can best win the cases. But listen, guys, it's a tough road, just like it's a tough world, and we're all kind of in it together. So it was a pleasure.
Daniel, someone, not to interrupt, someone had a good, Lynn, who is in here, has been asking some really good questions. She just asked a really good question. Is there any chance of a class action suit?
Yeah, we've discussed class action. What'll happen is we feel that it's better to bring individual cases. And it'll probably end up in what's called multi-district litigation rather than a class. And it's generally the same thing, except it's cheaper to run for the claimants. To run a class action is very expensive, particularly we're going to have, and forever, and we'll have hundreds and hundreds and hundreds of thousands of claimants. So I've been involved in what's called multi-district litigation, where for instance, on the mesh, we handle a lot of vaginal mesh cases, and they're all pending in New Jersey, but it's under what's called a multi-district litigation order, where people get to bring their own case, but you can piggyback in off those things that you feel are important to your case. So if you're a CNA insured, that person earlier, we're not going to depose CNA in every case. The lawyers who are involved in the multi-district litigation will do 1 or 2 depositions, or we'll get what we need, and then we'll use those depositions amongst ourselves. In Sandy, we didn't do a class action either. We handled each case individually. And eventually what happened, I had a lot of those cases, was the judge called us into federal court in Long Island, in Islip. He brought all the carriers in from around the country. This was after 3.5 years of litigation. We sat in a courtroom and we hacked the whole thing out, and they paid. But, so excellent question. At the moment, there's no class. And if we have our way through the trial lawyers and the American Association of Justice, and other advocacy groups, we're not going to have a class, but we'll have an MDL.
One other, thank you for that answer. We have another question. Am I in a stronger position because I haven't filed a claim yet, waiting to see if there are any judgments in support of business interruption insurance with an exclusion for viruses.
Okay, the short answer is no. And the real problem there, and I didn't really touch on this, is there is, in every policy, you have to notify your carrier of your claim within a reasonable amount of time. So I would immediately, and again, good counsel or your insurance broker, if they're a good one, can help you as to what you need to put. I was going to go through that here as well. And what I'll do when I send the email, I'll send a sample claim letter. For those of you who haven't put your carrier on notice, do it right away, okay? And do it you should be doing it in a manner that conveys the things that they're looking for in that claim letter. So it's not to your advantage to wait, because the carrier can say, look, COVID started, let's say for argument's sake, on March 15th, and your business, you didn't let us know that you were even thinking about making a claim until December. Well, where you been for the last 6 months? You have a notice obligation, okay? In New York, it's generally a reasonable amount of time, but some policies require 90 days. Some require 60. Okay, now, one of the arguments that we can say if you're late is that COVID damages are continuing. Or, I didn't really know what my damages were until August. But my advice would be don't wait. Put your carrier on notice right away, okay? I plan on making a claim, and here's the reasons why. We had COVID in my office, somebody was sick. The more information you can give them as to show that you really had COVID there or nearby, not just, I closed because of the pandemic. Okay, but at least that's something. But put your carriers on notice ASAP.
These questions are, everyone's been saying, Daniel, that the presentation is fabulous, very informative. They're thanking you and me for this. So
it's been a pleasure.
Just wanted to let you know.
I appreciate you having me on, and I appreciate what you guys do.
No, I'm not ending you. I just wanted to give you, I wanted to give you feedback.
You guys have me as long as you want. I'm here.
Yeah.
I'm here in this. I'm in the University of Michigan Law Library. So
someone just asked that, so I wanted to get that. They said, looking, Dan, great background. So
yeah, well, it would either be this or my mini golden doodle. So this is what we're going with.
Yeah, good choice. Good choice. You guys ask some questions, because this is just fabulous that, with his expertise and his knowledge. So people are asking, will you be, just to make sure that you'll send them a follow-up of, everything that you've been talking about?
I will. And what I'll do, embodied in that letter, or if I'll send a follow-up email, and if you respond to me, I'm happy to send a form claim letter that we've kind of fashioned that covers a lot of the things that the carrier is going to be looking for. They're not going to tell you what they're looking for until they deny you.
Right.
But and I certainly can provide that, gratis. Listen, I'm not, I've said it a couple of times. I'm not really looking to solicit. Clearly, if you wanted to use my firm, I'd love to talk to you about what your business loss is. And I'm a member, and that's where we are.
He is an active member, you guys. Daniel, I have another question. Will a claim denial result in higher premiums?
No, it will not.
Okay. You guys have any?
Now, look, there may be, there may be increases in premiums just because the world is changing. I mean, the carriers have a tendency to find a way to increase premiums no matter what, but there's not under insurance regulations in New York, there can't be an increase based on simply writing a claim letter. Now, even if you sue them, there can't be.
Any other questions? So what I'm going to do is, you guys, thank you so much for participating in this. I love these webinars. I learned so much from it, and I think it's a great opportunity for the businesses, because a lot of businesses, especially right now, can't afford an attorney. And just having this information and this background and knowing that Daniel is, you know, right around, he's a member of the chamber and he is right there for you, I think is very a great opportunity for you guys to, you know, you never know. So reach out to him. Well, he's going to reach out to you. So if you really think, someone just asked the same thing. Will fighting insurance companies make it harder to get coverage down the road?
No.
That's
it's a good question, and the answer is no.
Yeah.
No.
So I'm going to send Daniel a copy of the chat. He's going to have a copy of all the attendees. He's going to send you information. If you don't have his information, always email me and I'll forward the email right to Daniel. Daniel, again, thank you so much. We got more questions. This is great. Okay. Do you feel that insurance companies will be suing the government in some instances for the lack of direction or overbearing procedures now that the science is coming out?
There may be litigation in that regard, but it wouldn't come from us. You know, I'm not really concerned with what the carriers are going to do. I think the overriding concern from our point of view as business owners and people making claims is the carriers could take the position that if the courts find coverage, the losses are so astronomical that it's going to put us all the carriers will go out of business. So I know at some point AIG and Chubb and CNA and the big carriers are going to get together and they're going to make that argument and say there'll be no more insurance because the losses are in the multi-trillions of dollars for what we've gone through. Now, that's not particularly our problem, but it's a problem. Whether the carriers turn around and sue the government, if that happens, it wouldn't be the worst thing for us, but you're already getting coverage in a way from the government through the whatever public subsidies there are. You know, I don't know if the question is really asking, are the carriers then going to recoup the money that they've given you from the government? You can bet they're not going to pass it on to you. Would there be a quasi-government insurance partnership to cover these losses? That's a bigger question, and it's a little above my pay grade. I think we'd have to wait and see what happens politically and what happens with the carriers.
Someone asked, can insurance raise premiums if claims prevails due to loss ratio, meaning loss ratio in the specific case? So let's say we win and CNA covers. Can they raise my premium since they sustained a loss under my policy that they had to pay out on?
No, look, under the insurance regs in New York are pretty strict about that. That just because a claim is made, it does not necessarily trigger an increase. Your broker may say, well, there's going to be an increase because there was a claim. That really more applies to, let's say you're in your automobile, okay, and you rear end somebody and they have whiplash and they sue you. Yeah, your policy is going to probably be, you know, you're going to have a kick in your insurance because of your negligence. Okay, here, what did you do wrong? Okay, you didn't do anything. All you're doing is making a claim against your business policy. We didn't see an uptick in in policy costs after Sandy. We saw an increase, a little bit of an increase in those areas because of the flood risk. So again, the carriers may say, well, we're going to increase because the next pandemic's going to be just as bad, but they can't raise your rate if you're successful, if you beat them in court. All right, there are insurance regulations in New York that prohibit that, but the carriers are coy. You know, I'm sorry not to be definitive in your answer, but that's my lawyerly answer to that question.
Two things. If you can go back to your first slide with all your contact information, I think that would be great because people have been asking, and also give your, you know, he'll be sending you an email, but here's his contact information. Someone asked, we recently changed insurance carriers effective August 10th of 2020. Is it too late to submit a claim with our previous insurance carrier?
No, your policy covers the period of loss. So no, it's not too late. You can make the claim. Again, you have to give them reasonable notice. But it's the it goes by the insurance company that covered you during the period of the loss. Okay, so they're on the hook now for the section of my outline. All losses during the 1 year period are attributable to that carrier that you had at the time the loss was accrued. Okay, so not the new carrier, the old carrier.
People want to make sure. I'm getting a lot of requests for the outline to be emailed. Yes, he will email you all the information. For those that have I've been tracking who is on this webinar, but if you don't have your name, like there's a couple of people that have Zoom or something like that, you might want to reach out to him if he does not reach out to you. But I am sending him all the information. We do have a lot of call-ins. I track the number and I'll trace it to the registration. But like I said, here is his information. Let me see if there's any other questions because we've been getting a lot of pop-up questions. Quick question, Daniel, and not to put you on the spot, but some people in previous webinars have told me no, so no worries on that. Can I make this this presentation visible on our chamber TV?
Sure, I have no problem with that.
Okay. Yes, everyone. So, okay. So if you have any questions, here is Daniel's information on the computer right now. He will be emailing you his contact information. And like I said, if you have any questions and you can't get in contact with him, I'm sure you can, but if you lose his information, email me and I'll forward it right to Daniel. Daniel, thank you. I'm just looking at if there's any other questions. Let me just make sure.
Oh, you know, I see. I didn't put my email address.
Email address.
Yeah, it's a DTL at.
I'll put it in the chat. Hold on.
Yeah. Okay.
DTL
at lstriallaw.com.
I'm going to repeat that before I blast this out. D as in David, T as in Tom, L as in Larry at lstriallaw.com.
Right, 2 L's, trial law, 2 L's in the middle. Yeah, that's it.
Okay, I just sent it. We do have a question. Also back in April, I did ask our insurance brokers about business interruption coverage, and they said there would be no coverage. His response below, regarding business loss by coronavirus, to be sorry, the policy does not have coverage. I have attached a copy of the exclusion in your policy, and most of the insurance policies in USA have this exclusion. Losses by virus is not one of the covered causes in property insurance. Therefore, even the losses due to actions by civil authorities, there is no coverage.
Okay, listen, again, the brokers can give you whatever opinion letter they want. The courts are going to be the ones a judge is going to be the one who tells you on your policy whether or not that exclusion is applicable. Okay, again, I don't know if it's a USAA policy, a Chubb policy. They're all written slightly differently, and you know, it's in the fine-tooth comb stuff, guys. That's what these cases come down to. Look, I'm not telling you that this is a panacea and we're gonna be successful in litigating the case. What I'm telling you is you don't have to sit back and say, all right, well, I got a denial letter and that's the end of it. All right? Listen, there is an incentive on the part of the carriers to not litigate these cases too. And every carrier has written almost the identical claim letter as that I've seen. And I've seen 50 different carriers. Everyone's the same. There's no coverage, sorry. And 90% of the businesses in New York are just going to put that letter in a file and never pursue it. You guys, maybe, are going to pursue it. And you don't have really much to lose. I mean, what do you really have to lose in litigating the case? You got to get together your damages. I don't think that there'll be depositions on a lot of these cases because it just is a question of what the loss is and is the policy applicable. The courts will decide whether or not that exclusion is valid or not. Remember, it's written against the carrier. So, you know, in Missouri, the court is already saying, well, you don't need the physical damage. Again, we haven't gotten to the virus exclusion in the courts yet. That may be the death knell of it, guys. That may be it. You know, we may get a couple of decisions and end up going up to the Circuit Court of Appeals or the US Court of Appeals, and they say that those exclusions are valid. Sorry. It's a very real possibility here. But I'd rather the Supreme Court of the United States tell me than Joe Broker down the street.
Got it. Okay. Any other questions? Well, thank you so much, Daniel. I just think that I learned so much from it. So it's going to be, when we get calls from the chamber, I can actually refer to you, which is really nice. You'll be part of our, you know, our legal team. But thank you everyone for joining us. Like I said, my mantra is Daniel will be getting back to you, sending you his information. People are commenting, Daniel. I just want to, you know, I love to, you know, give the feedback. Thanks a million, Daniel and Helena. This was excellent presentation, very informative. People are just sitting there, lots of insight, great information, very informative. So Daniel, this was a great presentation. So thank you so much.
Thank you.
For those that are attending this, thank you so much for joining the Greater New York Chamber of Commerce. For those who are not members, we would love to have your support in connecting you with our database of 30,000 different business and civic leaders. And like I said, reach out to Daniel. He is he's your new best friend right now. So especially during this time. And you know what? I hate to be. I'm not saying that I'm putting it out there, but I think this is a new trial period for like a pandemic. I think that and the law. It's going to be interesting to see how the law and insurance companies either get together or figure this out. So, but Daniel is on the side of the business, and that's what the Greater New York is here to assist you on. And I just, one more question. Hold on. I just want to make sure I get everyone. Someone just sat there and said, highlight of my week, Daniel, maybe even the whole summer.
That's sad, but okay, thank you.
There you go. Okay, you guys, have a great day. And like I said, Daniel, I'm going to take a copy of the chat so you have it. And if you guys have any questions, feel free to email him. Everyone have a great day.
Thank you.
And I always say, please wear, you know, we're not political, but please wear a mask because New York is the leader of having the, you know, doing the right thing. So thank you so much.